It's the first time, so I'm happy that it's actually working. I think that we can now start, if that's fine for you, Juliana. We start with you, then we make a bit of a mix, and then we go to the questions. Thanks.
Great. Thank you, Mario. Well, good morning or good afternoon, everybody, depending on where you are. Well, I'm based in São Paulo, Brazil, so for me, it's just a sunny morning. Thank you all for joining us today for our Just Talking event, this time organized by the Antitrust Cycle of the Institute for Internet and the Just Society. Well, the objective of our event today is to cover some important topics regarding the current shape of competition law and policy in the digital era. Before I introduce you to our speakers today, I'll briefly mention the work of our institute. We are an open platform that connects civic engagement with interdisciplinary research focused on fair artificial intelligence, inclusive digital governance, and human rights in the digital age. And we are part of the antitrust cycle of the institute, which explores the particularities of antitrust in the digital sphere. So we aim to provide insight into normative and enforcement issues that data and other aspects of the digital world bring to competition law. So now passing to our speakers today, we'll have an interview-like dynamic. So Mario and I will be asking the questions. I'll give him the floor first so he can introduce Professor Dirk.
Thank you very much, Juliana. Okay, so Dirk, we're very happy to have you here. Dirk is a professor of law in two different universities in Belgium. I think it's in Liège, in Louvain, right?
Yeah, adjunct, I would add, you know. No.
Adjunct, okay, all right, okay. But you're also a senior fellow for law and economics at the International Center for Law and Economics. We're happy to have you because we already had a couple of your papers in under our eyes when we were developing our own research. I was very interested into the let's say the approach that you have on property rights for data, but also how you were addressing certain rulings from the European Commission, and when it came to specific mergers with some of these big tech companies. So because of that, then we were reaching out to you. You told us that there was an upcoming paper, and it was also raising the interest on that. And when I had an opportunity to read it, it was interesting because I saw that you were using these analogies of the narratives. You were using dystopian literature from Orwell, from Huxley, from Bradbury, to speak about all these fears that are coming from antitrust regulation and the big tech. And it's funny because as I was reading it, you reminded me this book from Akerlof and Schiller, Animal Spirits, because I don't know if you guys remember, there's a section where they say, and I'm not gonna quote by heart, but they say that our minds, or human minds, are made to think in terms of narratives, and that it's all like a sequence of events that have an eternal logic. It's not only like random event after random event, right? And then they say that that the same happens for governments and the same happens for organizations and companies. And I think that you were kind of outlining this in your paper, because what we have seen in the past recent months, I should say, coming from the US, coming from the European Commission, is that governments, but also companies and leaders are kind of shaping the narrative that is surrounding big techs. And this is why was important for us to read your paper. And I guess that with this, we can begin the discussion, and I can give the word back to Juliana to start with the specific doubts we have for you.
Thank you, Mario. So continuing explaining a little bit of our dynamic today, Mario and I will ask some questions, and by the end of the session, the audience will have around 10 to 15 minutes to provide comments or ask any further questions to the professor. So starting, well, our conversation here, well, professor has been working on a paper called Antitrust Dystopia and Antitrust Nostalgia, alarmist theories of harm in digital markets and their origins. So Professor, could you give the audience a preview of what your upcoming paper is about?
Sure. First, you can call me Dirk. That's fine. It's way
Okay.
better. So we've been working with my colleague and actually boss at ICLE, Jeffrey Manning. We've been working on this paper for what seems like forever. And basically the paper stems from two big ideas actually. One is about dystopias. So I guess everyone is familiar with dystopia novels. There's some of my favorite novels. So you have books like Brave New World, 1984, Fahrenheit 451, Animal Farm. And, these books, they probably have huge literary merits. I definitely enjoyed reading them. But if you then look at them from a more realistic point of view, they were kind of terrible predictions of the future. So, they got some things right. 1984 definitely, I think, saw the ravages or the dangers of communism. But what it missed is that basically communism, to a large extent, failed, and we live arguably freer lives today than we ever did before. Fahrenheit 451 was really about a world where books disappear and where visual media becomes the dominant form of expression. And the book gets that right. It does get right the idea that books are not going to be the only medium of expression, but what it then misses, what it gets wrong is sort of that arguably that hasn't prevented people from accessing information, quite the opposite, right? Today, you can access information on the internet, in a book, in so many different places. So it's not like, in some sense, the demise of the book has reduced access to information as Fahrenheit 451 believed. And you can sort of repeat that analysis for all dystopian novels. Now, the question is, well, we have dystopian novels, but do we also have dystopia policymaking? And so in the paper, we talk about one example, which is The Limits of Growth, that was published by the Rome Club in 1972. And basically, The Limits of Growth, the general theme of the book is, well, if current, so that's in 1972, if current growth trends continued as they did, very bad things would happen. So they predicted that you'd have more global famine, more global poverty, and that global GDP just couldn't follow, right? And it turns out that so they predicted that on a 100-year timeline, and now we're sort of halfway through that timeline, so we don't know what's going to happen in the next 50 years, but the first 50 years of that timeline have seen much increasing growth, much increasing global population, but decreasing famine, contrary to what was predicted, decreases in extreme poverty, and decreases in global inequality. So again, you have this pattern where there are severe risks that are predicted and that don't really pan out. And the question of our paper then is, well, what about antitrust law? And clearly in antitrust law, especially in the tech sector, we have these sort of dystopia stories that have been mentioned. And we cite one example, we cite many examples in the paper, but one salient example is, for example, Tim Wu's book, The Curse of Bigness. And I have a quote that from his book that I have right here. And he says about big tech has reignited debates over who really rules when the decisions of just a few people have greater influence over everyone. Their power feels like a kingly prerogative, inconsistent with our form of democracy. So I think when Jeff and myself, when we look at that, I think we really see sort of, again, this dystopia story where people are saying, well, given what we have today in the tech sector, we think there's a possibility that really bad things will happen. So we need to intervene today to prevent that possibility from occurring. The problem with that is that intervention it's never costless to intervene. And it's always possible to imagine how things could go really badly. But that's usually not the right basis for policymaking, right? So the question is, well, what do you do when you're faced with circumstances like those, where you have these possibilities of of really important harm down the road. And you need to make a decision today, knowing that there are costs and benefits, whatever you will do. One of the popular ways to address these problems is what's called the precautionary principle. And there are many, many versions of the precautionary principle, and they go from relatively modest to relatively extreme. So the most extreme is saying, well, if you want to put a product on the market or you want to partake in some kind of activity, if you can't show that that activity is 100% safe, or there's, some really, really high probability, almost 100, almost 1, that your activity is safe, you can't do it. So basically, when you weigh the costs and benefits of a given activity, you just focus on the costs. You don't weigh costs and benefit. Now, so that's sort of the most extreme version. And you can go towards more modest versions of the precautionary principle. One more modest version would be to say, well, okay, in most cases, we should weigh costs and benefits, because we realize that if every time that something has some slight risk, we prevent it, we'll prevent a lot of good things from happening too. And someone like Nassim Taleb, I think, has written quite interestingly about that, saying, look, the one place where you do want the precautionary principle, or where there's room for the precautionary principle, is when you have a risk of ruin. That's what he calls it. So if something, it's not as much about the risk of some cost occurring, but if you think that a given activity could lead to ruin, so things like pandemics, really exponential harms that would cause humanity's demise, okay, then there's maybe some room to depart from cost-benefit analysis and give a bit more weight to potential harms. So we with Jeff, we don't reach a conclusion on what the right version of the precautionary principle is, or whether the precautionary principle is good or not. But what we do say is, well, look, if we take this version of the precautionary principle, Nassim Taleb's, we don't think that those factors are present in the tech sector today. And so I'm happy, as the conversation goes along, to explain why I don't think that we have that sort of risk of ruin in the tech sector today. And just one more thing on that, the problem with the risk of ruin is that it's sort of irreversible harm, right? It's sort of, okay, would it get so bad one day that you can't just say at that point, okay, we see this harm occurring and we're going to do something about it? So much so that we need to intervene before it occurs. We don't think that's the case, and I'll explain.
Well, thank you very much for the overview. Well, what I thought the most interesting thing about your paper is this connection that you found between fiction and policymaking, and actually connecting that to current trends happening in antitrust right now. And well, your paper certainly does provide us with a point of view that is very different from the current trends happening in, at least in the antitrust agenda in Europe. But I was wondering, well, we all know that the economics of digital markets are a little bit different from traditional markets, but I was wondering if you could develop a little bit more on what would you say makes digital markets unique in a certain way?
Okay. So maybe I'll take half a step back, which is a lot of the discussion in digital markets is these markets are somehow different, and though it's not said in those words, they require intervention that is along the lines of the precautionary principle. So one example of that could be the European Union's Digital Markets Act, where basically we're going to establish presumptions that a given course of behavior is harmful. And we're not going to allow firms, we're going to preemptively prevent firms from doing that. We're not going to allow firms to justify that behavior and saying that it benefits consumers. The question then is, well, what kind of evidence do we have to say that these markets are particularly prone to anti-competitive problems that cannot be solved ex post, that need ex ante intervention? And so there have been many, many reports published about competition in digital markets. And I think that's two sort of important themes here. One is the idea that data is the new oil. So firms that will first acquire a property right over the so-called wells, so over underlying user data, that those firms will then run away with the market. That you can, when you think of the data oil analogy, and even that is not very good, you could sort of think of it in terms of, well, there's only a finite number of oil wells in the world, and once those have been propertized, then that's it. And if one firm propertizes all the wells, then it will have a monopoly. I'm not even sure that that's actually true about oil. I don't think that's true. I definitely don't think that's true about data. I don't think there's only one way you can get data, and I'll get back to that in a minute. The second point that's made, it's a bit more technical, is that you have data-related incumbency advantages. So these could be, many have been mentioned. The common ones are network effects. So these markets, users value platforms with more users on them. So you get tipping, or maybe you can have the two-sided version where people on one side of the market value more people on the other side. And again, you get this dynamic, sort of a self-reinforcing dynamic where the strong become stronger. An interesting spin on that has been the data network effect point, which is, I'll get back to that in a second, but the idea that once firms acquire data, they will improve their products with that data. Maybe they'll improve their advertising, maybe they improve their platform, and that makes them stronger. And because they're stronger, they get more, or stronger or better, you name it. And because of that, they get more users, and then they get more data, and then they get more users, and so on and so forth. And so again, the idea is that once you have a leader, that leader will not be able to be dislodged. So that's the result. I don't think that there's extremely strong evidence to suggest that this is actually how competition will play out in digital markets. I'm not saying that these aren't important competitive forces. I'm not saying data has no value. It clearly does have value. I'm not saying that network effects theory is wrong. It's clearly a very interesting theory. But the question is, does that theory mean that once you have an incumbent, that's it? Competition in the market is almost entirely reduced and you'll never see someone else overthrow that incumbent. And I think that point is, in my opinion, almost certainly wrong. So maybe I can focus on some of these points in maybe in a bit more granular way. So one, the data is oil point. I think one of the responses to that is, let's think of data as information. And I think that's the right way to think about data it's right to think about data as an information good. And information goods have certain characteristics where in other markets, we actually think it's quite hard to use information to sustain a competitive advantage for a very long period of time. One reason is that data or information is very hard is partially at least non-excludable. When you have a given piece of information, it's very difficult to prevent that information from leaking. And if you're going to use that information to influence your own behavior, it's very hard to stop people from just imitating your behavior. They don't need the underlying information if they can observe what you're doing with it. So that's a hard way to sustain a competitive advantage. The other big point is data is non-rival. And here I think the way it's important to think about it is, just because Facebook has all sorts of information about me, one, it doesn't prevent anyone else from acquiring that same information, another platform from acquiring that same information about me. And both platforms can use that same information about me simultaneously. So essentially what competition becomes about in these markets is, well, can you find a better way of convincing users to give you their data? Or, that's even that framing is not entirely perfect, because it's not very often with a platform, it's not like you give your information to the platform. It's not always clear that the information or the data pre-exists your relationship with the platform, right? For example, I have an IMDb account, and on that IMDb account, I rate all the movies that I've seen. Without IMDb, the data, how I appreciate all the movies I've seen, that data would be sort of some vague concept in my mind. It really took IMDb to actually reveal that and make it actual data. So I don't know if it's my ratings on IMDb. I'm not sure that it's my data or that it's IMDb's data in a way. I don't know who contributed more to the emergence of that data set. Anyway, sort of the general point here is we shouldn't assume that just because one firm right now has the biggest data set about something, factor X, that doesn't mean that another firm won't find a different way of obtaining that same data. So maybe a way you can frame this is what David Teese calls dynamic capabilities, where the challenge really for firms in these markets, it's not just to obtain data, or it is, in some sense, it's obtaining data, but it's really about finding new ways to obtain data, new ways to obtain insights for it, new ways to make money from it. So I can give you an example. If data was all important, if just access to data was all that mattered, in 1998, I think it's 1998, Google entered the search engine market. It competed against incumbents that almost certainly had much superior access to data than it had. But what it did is it changed the market paradigm. It did something completely different. Instead of offering like a big classifications of the web like Yahoo did, Google just went with that one search box and the 10 blue links, right? And that story has many lessons. One, it's not just about how much data you have, it's about actually doing interesting things with that data. A second part of that story is that to get the data to make its search engine work, the main data that Google relied on was just crawling the web and using publicly available data. So again, it's not clear that it's not all about how much data you have. It can be about getting data in new and interesting ways. All of this to say that data incumbency seems difficult. I think the second really big version, or the second big point that people make with regards to data in these markets, is the data network effects story that I mentioned. So the idea that once a firm, that it's a self-reinforcing circle. Firms get data, and the more data they have, the more their competitive advantage increases, right? And so you could say, well, do you have data-related economies of scale? So for the more data you have, every extra increment of data increases your output more than the previous one, right? And there's actually empirical research that looks at this, and that no empirical research is perfect, but the empirical research that we do have suggests that it's not the case that data, that additional data always improves your product a little bit more than the previous data. In fact, the general consensus seems that there are sort of diminishing returns to acquiring more data. So, you have studies by Catherine Tucker and Pajari and other people like that. I don't know if this is the right place to discuss those studies, but they're interesting. People say, there's a response to that, and I think it's important, which is to say, well, to undertake these studies about the value of data, you need access to data from the online platforms. So maybe that skews the results a bit, That's a fact. I think, that's a possibility. But it doesn't mean the opposite either, right? Just because that research might have problems doesn't prove the opposite, that data does lead to increasing returns. So, and it's important to add that that research is peer-reviewed, often in very highly prestigious journals. And so there are, these journals are used to dealing with issues of this kind and presumably have strong practices in place to prevent skewed studies from emerging. So.
Well, thank you very much for the
go ahead.
answer. I'm sorry if you were gonna develop a little bit more, but I think we could connect this to the next question. Well, you make a very interesting point about the analogy between oil and data, and I personally hate this quotation, data is the new oil. I think it's quite annoying, and especially like you said, oil is, well, a commodity and economically rival good, while data is not. So there's a clear misconception about the two concepts. And well, connecting the discussion between data and antitrust law, there are currently many civil society organizations engaging in the debate around antitrust in the digital economy, and they seem, well, especially concerned about the relationship between data and market concentration, and, well, especially concerned specifically about the impacts of this for consumers, well, for internet users in general. An example of this is the movement of international NGOs, for example, that are opposed to the Google Fitbit merger recently. So my next question is, do you think there's a clear boundary between competition law and data protection? And what are the limits of this discussion, and which barriers should be trespassed or not when dealing with data relevant antitrust cases in general?
Yeah, so that's a big question. I think there are a couple of, I don't have a definitive answer. I think there are a couple of points that are important. One, in the field of competition law, so data protection law seems to pursue objectives that are somewhat different from competition law. But when we talk about data protection in competition law, I think one part of the puzzle is important and seems to be overlooked at the moment. And it's the idea that the world isn't sum zero. Just because I've given some piece of data in exchange for services doesn't mean that I'm worse off, right? So maybe I can be a bit more concrete about it. There's this idea that, the more data you give to a platform, or the more, give isn't even the right word because it's not necessarily yours to give in the first place. But the idea is the more data the platform acquires about me, sort of the worse off I am. And I don't think that has to be the case, right? For example, if I use Google search engine, is it really worse for me when in addition to the organic links, I have some sponsored research? In fact, there is empirical research about this question, and it suggests that at the very least, having targeted ads may improve users' experience, may improve click-through rates. So that's the first part. I think it's wrong. In that example, it's wrong to assume that just Google having more information about me is necessarily bad for me. So I think that's one important point. A second point in the debate then is more about the relationship between data protection laws and competition laws. It's a complex question, but I do think that the sort of at least one minimum requirement should be the following. It's not an infringement of data protection laws should only also be a Section 2 or Article 102 competition infringement if it was made possible by the firm's market power, right? Because deep down, I think what competition laws are trying to achieve is control certain types of behavior that emanate from firms' market position, right? Now, I don't think, and I could be wrong, I don't think it's clear that firms infringing the data protection norms or regulations, I'm not sure that that is tied to their market position. And so I'm not sure that competition law is the right tool to police that type of behavior. And it sort of goes back then to the first point I was making. If you look at the Facebook German case. So for people who aren't familiar, the main argument is Facebook, I'm simplifying, but Facebook takes data from users when that's generated when they are not on the Facebook platform and merges that with its own data from the Facebook platform. And there are many arguments put forward, but one is that is just exploitative in and of itself. It doesn't seem obvious to me that that's the case, right? Maybe that's not okay from a data, a GDPR standpoint. I'll leave that question aside. But if you're looking at it from a consumer welfare standpoint, just are users left better off or worse off when Facebook combines this data? The answer isn't obvious to me. If that data, if the end goal of that data collection practice is to give users better ads, if it's to compete against other online advertising platforms and offer a better Facebook service to get users on the platform and to view the ads, again, it doesn't seem self-evident that behavior is harmful. It has been, I think it's fair to say that authorities see that as harmful in and of itself, and I think that's wrong. There's a second aspect then to the case, which is, does that data acquisition practice, does it sort of prevent other rivals from competing? And there again, the question goes back to, is this just the fruit of market power? Can Facebook do that because it has much higher market power than other online platforms? Again, I don't think that's the case. And if there is a problem, it seems to be much more one about information asymmetry. And then again, sort of more something that data protection laws should be dealing with. There's a whole debate about what type of data protection laws you should or shouldn't have. And I don't know if that's the topic for today, but.
Just a comment there, because we were not considering, of course, the Facebook v. Federal Cartel Office when preparing the questions, but it's certainly a very interesting case because it kind of gives you the bit of an evidence of what this material overlap might be between the data protection law and competition law. I'm not going to follow step by step the reasoning from the Federal Cartel Office, but as you said, what is interesting is that they don't claim that Facebook is per se a dominant company in the market of social media and advertisement, because the amount of data itself, the amount of data that they harvested was, let's say, a secondary thing that happened after the accumulation of power, right? But what they say, and this is why it is interesting to see what is the level of maturity of the authorities and the courts of law when analyzing these cases, is the type of theories that they need to take into account when analyzing the cases. Because if you remember, what they did in the case of the Federal Court of Justice in Germany was to use a civil law case as a theory of harm that was coming from abusive contractual terms. Because they said, when you have a party that has substantially more power than the other, that prevents it from any type of bargaining power when it comes to what are going to be the applicable terms and conditions. And in this particular case, the terms and conditions were that they kind of, according to the authority, gave up on their data so that the data could be used then for further, processing activities together with a third-party data that was harvested. There was a need for the intervention of the court. But again, we're not going to jump into that for the moment, because I guess that we have some more reasonable questions following. But then I stop it there and I give it back to Juliana.
Thank you, Mario. I think actually Professor Dirk was finishing his answer, or maybe not.
No, I mean, I'm just happy to respond to what Mario just said.
Okay. Yeah.
You know, I think it's probably wrong to assume that consumer demand is completely inelastic here. So whatever users Facebook has, it would have as many users if it just did more things that users don't like. I don't know that users are really fundamentally unhappy when Facebook takes more of their data. Maybe it's the case, you know, there was an incident with the WhatsApp terms of service. I think it must be a couple of months ago, but it seems like yesterday. And that seems, you know, it's not empirical research. It does seem to have had some kind of impact on the users' use of WhatsApp. You know, a second point that we haven't just sort of, again, when we talk about these anecdotal things, if data is the be all and end all, you know, and network effects are impossible to overcome, why do we have firms like Zoom that emerged when, you know, you had Microsoft with tons of data, a service that had been there for a really long time, you know, namely Skype, and sort of at this point, it seems fair to say that it was completely outcompeted. You look at another, you know, you say, oh, okay, maybe that's just voice and video calls. It's different. Okay, well, what about a platform like TikTok? Like there again, you see sort of, you could think that, well, because Facebook and Snapchat had way more data, that they would be completely protected from the emergence of TikTok. That doesn't seem to be the case. And if you look at how VCs talk about these markets, it seems to be much more about, can they offer a new value proposition to users? So I don't think we've sort of reached the end of the world and the end of competition in digital markets, but maybe I'm being an optimist. I don't know.
And I guess that one significant piece of evidence of whether or not the consumers were interested into privacy was, as you said, what happened after the privacy policy of WhatsApp. No, they started jumping into some other competitors, and they were claiming, some of them, that privacy somehow should be considered also as a part of the consumer welfare approach, because some people, of course, and perhaps a limited scope of them, were considering that data protection should be taken into account when you were setting up the way in which you were processing the data in the context of a messaging application. But that, again, it may be different from one user to the other. And I guess that from there we can jump to another question. And again, using the example of WhatsApp and also the case for Instagram in the context of the Facebook acquisition, which is, do you believe that it is some sort of piece of the process of innovation, the acquisition of startups? And do you believe that this at some point could also prevent for innovation to flourish when you just start taking over on the companies that are developing their own solutions?
Yeah, so that's a really complicated question, and a very it's a sensitive one in economic circles. So maybe I'll try and do a bit of setup. There has been a lot of discussion about big tech firms acquiring small startups in order to prevent future competition. And basically, it's been framed as these startups and the big tech platforms both have overlapping innovation R&D pipelines, and absent the acquisition, they'd be competing. And because big tech platforms know that, they preemptively acquire the rivals, right? The question is, you know, what kind of evidence do we have for that happening? It turns out there is some evidence of that in the pharmaceutical sector. So most people are probably familiar with the Kira acquisitions paper by Florian Ederer, Cunningham, and I forget the third author. I'm really sorry about it. So what they show is that, and I'm not going to get the exact percentages right, but that somewhere between 5 and 7% of acquisitions in the pharmaceutical sector are killer acquisitions. That is that acquisitions with overlapping R&D pipelines led to higher project discontinuation rates. That's not exactly the same thing as saying that those transactions decreased consumer welfare, because it's important to counter that in this space, higher profits, even if they acquired a monopoly rent thanks to the acquisition, that monopoly rent, or other firms perceiving that there are monopoly rents to be had in this industry, that could act as a way to increase incentives to innovate. So the welfare effects are not 100% clear. But let's say that the authors are completely right. Let's give them the benefit of the doubt. The question is then well, what do you do about transactions that occur 4, 5, 6% of the 7% of the time in the pharmaceutical sector, which has very particular features that maybe facilitate this type of transaction? Namely, in the pharmaceutical sector, products have to go through a very long and visible regulatory pipeline. So it's relatively easy for an incumbent to identify its potential future competitors, right? So that's pharmaceutical. What would that percentage be in the tech sector? No one knows. There's no empirical research on that in the tech sector. But if you just look at economic theory, you'd think that those killer acquisitions would be less likely in the tech sector because you don't have that same product R&D pipeline. So what do you do then about something that's a small percentage of mergers? And in a paper, so we've been working on a paper about this, and it's about to be published in a law review with Jeffrey Manny and Sam Bowman, my colleagues. And one of the answers that we think is important is the error cost framework says something about that, which is, well, can we identify ex ante the small percentage of mergers that are likely to be killer acquisitions or anti-competitive, anti-innovative acquisitions? It turns out that it's really difficult, right? There are no obvious heuristics to identify those mergers. The best one is just to say, well, it's mergers where there are overlapping R&D pipelines. But even that question, even that may be way over-inclusive. We don't know. But even answering that question is incredibly hard, right? So when you look at mergers that are now being talked of as killer acquisitions or acquisitions of nascent competitors, so mergers like Facebook, Instagram, Facebook, WhatsApp, Google Waze, you look at these transactions, maybe it's less the case for Google Waze, but especially the Facebook ones, it wasn't entirely clear at the time that these firms were, competing and were R&D competitors. They were in the same industry, that's for sure, but does that mean that from now onwards, every time you want to acquire a firm in the same industry as you, people will say, look, that firm could potentially be a competitor in 10 years' time, so we should prevent these acquisitions. Against that, there has to be some kind of account of the benefits of mergers, right? Otherwise, we're just in the sort of precautionary principle realm where we say all that matters is potential harm. I think we need to think about the benefits. Some of those benefits are synergies. There's managerial efficiency on the part of the incumbents. There's access to capital. That's really important, right? You shouldn't assume. It's easy to assume now that Instagram would have become the platform that it is without being acquired by Facebook. But when Facebook acquired Instagram, they invested a lot of money in the project. Apparently, Mark Zuckerberg had ideas about things that would be valuable, like Instagram stories. I don't know if that's apocryphal or if it's true, if it's fact, but it has been suggested that stories became what it did in part thanks to Mark Zuckerberg, and that's now a really successful part of the Instagram platform. So would Instagram have been what it is today without that acquisition? It's not clear. There's other efficiencies. There's definitely some value to combining different products in the same platform and making it very easy for users to move from one to another. again, I'm not saying that all big tech mergers are good, but I don't think that it's also clear that all big tech mergers aren't bad. And so the question becomes, well, how can you sort the good from the bad? And if you can't sort the good from the bad, what should be the baseline presumption? Is it more likely that these mergers are harmful, or on balance, are they more harmful to consumer welfare or more beneficial to consumer welfare? It doesn't seem to me that we've answered these questions well enough for the moment to say, well, antitrust authorities should now be really concerned about killer acquisitions and so should aggressively lower notification thresholds to sort of look at every single acquisition by a big tech incumbent. But there are many open questions.
Definitely. And that leads me to ask you, and I guess that also that's where we left it when we were allowed to be outside without these boundaries. I think there was in 2019 a conference that was actually asking that question: is are regulators well equipped to answer to all these concerns, and do they have the tools that they need also for facing these challenges? And the following question is actually in that same vein. So on the one hand is, do you believe that regulators are well equipped and are well aware about these challenges, and do they have the capabilities for analyzing the huge amounts of data that sometimes, of course, would be relevant for the investigations? And a bit aside, do you believe also that legislators and the people that are currently making the policy that is going to be applicable also were well aware about what to take into account?
Yeah. So it's hard to say, but I think it's right to separate legislators and decisions. So maybe I'll start with sort of legislators or competition authorities when they're, thinking about their priorities, thinking about changing rules and things like that. What kind of information do they need? It seems to me that the kind of procedures that you have now aren't lacking. A lack of technical expertise, to me, doesn't seem to be the major problem. So, right, the way the Commission and other authorities seem to have proceeded for the moment is you have a question, maybe it could be about algorithmic collusion, it could be about the power of big tech. And basically the way you go about answering it is you amass a group of experts that are, you get an expert economist, you get some people from the industry, you get some lawyers, you get them to write a report, and that presumably tells you how to proceed. I don't think that in that process, the weakest link is that it's hard that people don't grasp or that you don't have people that are aware of how the industry functions, right? It doesn't seem to me that that's the big obstacle. I think a much bigger problem with that process and a much harder part to address is, well, just what I said about big tech platforms and empirical research about how they use data. That may be biased because the platforms at the end of the day are the ones deciding who gets the data, their data. Well, you get the same thing when an antitrust authority is going to hire some experts and get a report published, right? Which is, they don't just hire any experts. They're hiring experts who presumably they think are going to say something along the lines of what they want, right? They're not, I don't think that they're any more or less naive than firms. So I think what you see in these reports, from my point of view, is that usually you get one point of view, and that point of view is very well made. I don't think there's any problem about the lawyers speaking to the engineers and to the economists, but it's just one point of view. So I think that's the weakness with that process. You could then go to a second part, and which is maybe that there the problem is more salient. It's deciding actual cases. And there I think to me, two really important questions. One is more a question of principle. It is, should we design an antitrust policy that we know is going to require these really complex assessments? Is that a good or a bad idea? And I don't have a definitive answer. And the second one is if you do have an antitrust policy that at some point requires really hard technical assessments, how should you go about acquiring that information? What's the process to get it? So maybe I'll start with the second. Like, courts have been doing this for a very long time. And there's sort of a standard method that you can use to get technical information, which is you say to both parties, each of you hire one expert witness. And if you really think that you're not going to be able to distinguish between the good and the bad witness, so to speak, you can get both expert witnesses to agree on an impartial third witness, right? That's sort of incentive compatible. It shouldn't be too much of a problem. You know, that suggests that I don't think authorities necessarily need to have in-house experts, because there's always this possibility of outsourcing. There may be an exception to that. If authorities at some point realize that there's a real learning curve, or that every case that they're going to face is so similar and requires such similar expertise that there's value to having sort of the in-house expert, then there's maybe a stronger case to say, well, antitrust authorities, you should specialize, and you should have engineers on board who are better situated to work on these cases. Yeah, I don't have a definitive answer. I think there's a nice case that illustrates these considerations is the Google shopping case in Europe. So one of the underlying questions in that case was whether Google redesigned its Panda algorithm so as to demote its vertical search rivals. And you sort of get these considerations, which is, to answer that question, you could go about it in many ways, right? You could look at internal communications from within Google, and maybe you get email exchanges that show Google really redesigned the algorithm to demote rivals. You could look at it from an economic standpoint and just look at the effects. Maybe you don't need to understand how the algorithm works. You just look at the market effects, okay? And there the difficulty is causality. I forgot to mention, but the difficulty with the emails is that authorities, there's an amount of cherry picking, and you can find a lot of stuff when you go through internal emails. And then like the third possibility is, well, it's the technical expert one. You get engineers to look into the algorithm and figure out how it works, and whether given its design, the only intent could have, the only plausible intent was to demote rivals. I don't know that any of those three things is particularly stronger than the other. They all have limitations. The limitation with the technical expert one is, I think it's wrong to assume that you can just get any engineer looking at the algorithm of a firm and understanding it. It seems to be that even the firms themselves often don't really understand why algorithms produce given results. It's complicated. If it's something that human beings could do really easily, we wouldn't need algorithms. So, given those complexities, I think there's a broader question, which is, how should we design antitrust policy so as to make sure that we only get bogged down in those questions when it's absolutely necessary? And in the Google shopping example, I think there was a really important counterargument that my colleague Jeff Manny has made many times, which is vertical search firms in that case made themselves entirely dependent on Google's ranking. That was their main source of traffic. They knew it. They entered with some risks. Jeff talks about antitrust nostalgia, right? Because basically Google's business model is always improving its algorithm, right? It's always about making those search results better. So a firm that makes itself really dependent on the status quo of that algorithmic ranking is in a very precarious position. It's not clear to me that antitrust should protect that type of behavior, right? Basically, it's like the question, should antitrust be ensuring vertical search engines against sort of, not even expropriation, against behavior that undermines them. I think that's probably a more interesting or more important question than how you address the technical intent and algorithmic design question. I think it's better to function at that level and say, well, maybe there was something flawed about that case, and then pursuing it further, antitrust authorities are left to answer questions that are in some sense unanswerable.
Thank you very much, Dirk. We do have a lot of remaining questions, but I guess that it's also fair to give the word to people that are joining us. We were asking them if they have any question that they would like us to submit to you. I still don't see anything, so perhaps.
Yeah, there's a question from David, actually. I'm going to read it. I would like to circle back to one of the first questions. What role do you see data brokers playing in antitrust enforcement, either to facilitate other markets or as market in themselves? There are huge data brokers, especially in the health data business, designing tailor-made proprietary databases to R&D departments of pharmaceutical companies. And if you shift focus to the data brokers themselves, data is no longer viewed as an input product, but would rather be the main object of antitrust law itself. So this comment is from David. Feel free to answer it, Dirk.
I have great trepidation about talking about ad tech markets. I'm kind of reluctant to do that, if for only one reason, that it's an incredibly complex market, and I don't want to say anything foolish. And I have not written about ad tech specifically, so I'm not sure I can answer that question in a convincing way that won't do more harm than good, so to speak. I'm looking at the question right now, and I'm, maybe the only point I can say from that is kind of anecdotal. It's like you hear hearings before Congress, before the Senate sometimes, and people struggle with even the idea that these platforms, Google, Facebook, make money from advertising. That's why they're free. And so when you then move to what the market actually looks like, there's like an intermediate version, which is just the two-sided market framing. Oh, these are platforms, they make money from ads, and that enables them to offer nice products to users. And in exchange for that, users have to view ads. That's still a gross oversimplification. And like the real functioning of those markets is incredibly complex. I think that's maybe the only lesson I can draw, is that we need to be careful about framing these markets in certain terms, because they're invariably much more complicated than we think before we look into them.
Thank you. We have another question by Hassan. He's asking us, how can you claim ownership of your data in social media after you click on accept on the terms and conditions? I tend to think that you should, so I don't want, this is a sensitive topic, and I understand that most people probably don't read the terms and conditions. And so there's some argument to say, well, if people don't read them, how can we expect them to be bound by what's in those terms and conditions? I think it's sort of, when we frame it that way, it goes to a point sort of all the way back to Milton Friedman, which is, what matters is not whether people have read the terms and conditions, it's whether they behave as if they understood what's in the terms and conditions. And I think today, users understand, I think there is a new paper about this, but I don't know. I haven't read it. But I think users have at least some vague understanding about what it means to be on a social media platform or a search engine. It means that some data about how you behave on that platform, maybe outside of that platform, is going to be used to serve you digital ads. People may afterwards say, well, I didn't read those terms and services, hence I am not happy about what's in those terms and services.
I'm not sure that the right way to go is to say, well, because you didn't read, you're off the hook. It may be just that you don't need to read the terms and services. You just have to be slightly aware about, like reading a newspaper every so often, understanding how those markets function. There are tons of examples like that where, you have sort of contracts of acceptance. People accept the terms in a contract. And I think the literature on that doesn't say, well, those are inherently exploitative. What the literature says is people, there's some vague understanding. Some people are very conscious about those contracts, maybe consumer NGOs, things like that. And if there's something egregious in the terms, it will be made public and the company will suffer some kind of punishment from consumers. That's arguably what happened with when Facebook updated the WhatsApp terms. So I don't know, and I don't think you sort of get necessary. I don't think, at least from a policy standpoint, that you should necessarily be excused for not having read the terms and conditions and then saying, well, I'm the victim of whatever happens afterwards. But that's my point of view.
Thank you. So I don't think we have another question. We can of course wait, but we had one that I really liked, which is related with China and its own, let's say, participants in the tech market. So we know that they somehow have been, like keeping themselves apart from what was happening in the big tech for the American companies, for instance. And we now have the fact that they were fining, the Chinese regulators were fining Jack Ma's Alibaba Emporium. And I would like to ask you, from, let's say, because it's China, it's interesting from the ideological point of view. What do you believe that could be a possible future for the big tech in China? You may, if you want, land it into the regulatory point of view, but what's going to happen with big tech there?
Yeah, it's a huge question. So there are many. One, I am not super familiar with Chinese antitrust. So whatever I say next, I say it with a huge caveat that I find the question interesting, but I don't consider myself an expert by any stretch of the imagination. When I sort of heard about the Alibaba case, I sort of have three things to me that spring to mind. One, it seems to be that whether you have Chinese antitrust authorities, European antitrust authorities, or American antitrust authorities, they seem to be focusing on the same things in these markets. And so the case against Alibaba seems to be sort of not that distant to what you get today in the European Union against Apple. It's sort of a free riding, steering question. I don't have strong views about the underlying market. I haven't looked into it in detail. But so that's just one point, right? It seems that global regulators are focusing on the same things. There are other points. So one, there is a sort of industrial policy point, which is Chinese industry. So you could sort of think of, maybe I'd think of them as the big three antitrust regimes, the Chinese one, the American one, and the European Union one. And all three of them, to varying degrees, incorporate industrial policy considerations or decline to incorporate these industrial policy questions. It seems to me that in the Chinese, the Chinese regime is much more overtly partaking in industrial policy, sort of thinking, well, we should think about what's good for China and we will act accordingly. It seems to me that at the other extreme, like when you go to the sort of antitrust common law system in the United States, that's less influenced by industrial policy considerations, or at least less overtly. And the European Union sort of, to my mind, sits somewhere in between, where I don't think they're protectionist, but it does seem that the European antitrust rules are designed in a way that reflects maybe the European experience of digital competition. So it's like European antitrust isn't specifically targeting American tech firms, but it is an antitrust system that is relatively tough on big tech platforms, and those tech platforms happen to be American. So, is there some influence there? I don't know. Anyway, China seems to be quite heavy on the industrial policy. And so much so that the Alibaba case has been sometimes framed as more about the relationship between Chinese authorities and Jack Ma than actually antitrust. And finally, like, I think an interesting question, and that's like, I don't know what the future looks like, is the future a global internet, or is the future a fraction splintered internet, depending on each sort of regulatory area? So if you read the work of, say, Anu Bradford on the Brussels effect, you would guess that the most likely is the first, that you'll have global convergence. Basically, the first authority to regulate will influence other authorities and you'll get convergence. There is another story here, which is the opposite, that more and more regulators are going to start adopting decisions, and consumers in different parts of the world are going to be faced with a different internet with substantially different services because of regulatory factors. So you see that's happening to some extent with the GDPR. Already now, some websites aren't available in Europe, and maybe you will that trend will continue. You see that with data transfers, where at some point, will digital platforms be able to transfer data from Europe to America? And if they can't, does that mean that the European platform is going to become very different from the American one? You know, I don't know, but it seems like this is a huge issue, and I haven't found anyone that that knows where it's going. Something to follow.
We don't know either. Dirk, finally, because we ran out of time, when is the paper going to be published?
So the George Mason Law Review one is now, so the Antitrust Dystopian Nostalgia is accepted at George Mason Law Review, and it will be out. Gee, I can't remember the date, but it will be in the next 6 months sometime, but I can't remember the timeline. And then our killer acquisition paper is also accepted and will be published, that one, I think, in the fall. So
okay, we'll be making some proper advertisement about it, don't worry.
Thanks, that's awesome.
Definitely. Thank you very much, Professor, for the conversation we had today. It was lovely to have some of your perspectives. I think it's very nice to have these different views on antitrust, because we are very much used to the current approach that you criticize so much in your paper, and it's really interesting to have this other perspective as well. I'd like to thank the audience as well for participating today. And we have our next event organized by the Institute on the 6th of May. So you're all invited to join, and well, of course, after that, we'll continue to have these conversations during weekdays, and we always have guests, and every time it's organized by a different cycle in our institute. So you are all very much invited for that. And thank you, Mario, as well for helping me conduct the interview and all of it. And have a great afternoon, everybody, and thank you very much again for your participation.
Thank you so much for the invitation. It was awesome.
Thank you very much, Dirk. Have a good day.
You too.
Goodbye.